welcome to webinar. I am Chris Hynes, former Commissioner for Body Corporate and Community Management, Strata Adviser, Hynes Legal. And Frank Higginson was here literally a nanosecond ago and has vanished. Frank, I think, is having just a couple of technical difficulties. I'm hoping that we'll see Frank in just a second. So please bear with us, everybody. For now, as always, thanks everybody for tuning in. Don't forget to pop your comments up there if you have any live or afterwards. Here's Frank right now. Welcome, Frank Higginson.
I went to shut my computer screens and I shut all of Google Chrome rather than just the ones I wanted to shut. So that's
understood. That's a very common thing, that one. Fortunately, we haven't gotten very far, Frank, so that's good. Just done a few introductions. By all means, chuck us up a few comments today, live or after the event. Don't forget to please register for these events as they come along. That's how you will get some content and also find out what is coming up in the not too distant future. Today, Frank, the murky, mysterious world of adjudication.
Oh, well, murky depends on who you're talking to, doesn't it? Yeah, it's an interesting one, I suppose. We have a substantial degree of flexibility about what we talk about. And I know Chris still does it every time in terms of, like, adjudication decisions don't pop up every day. They come up in swathes, don't they? Here's the last 30 or 40 or whatever it might be. And Chris always reads them and always will send through, look at this one. What about this one? So we thought, as a bit of a breakdown, 3 interesting decisions, and of course, how we could have helped or what people could have done differently, I suppose. Bit of a combination of the two, and see how it goes.
Couple of points to make at the outset before we get into our first one. A quick adjudication 101, Frank. It always helps to clarify what we're talking about. So adjudication is about getting a legally enforceable and appealable decision. Adjudicators, they're independent decision makers, aren't they, Frank? And they're not subject to, so when I was Commissioner, I wasn't telling the adjudicators what to write or what to decide. They decide that themselves. So they're a bit like a magistrate, aren't they, Frank?
Or a judge. I mean, they're really a judge because they have material put before them, they make a decision. And the difference, I think, from adjudication through as against courts is adjudication is supposed to be an inquisitorial process, isn't it? Where the adjudicators will actually go back to people and ask them, what about this? And can you give us this material? And they can ask for information, and they quite often do that. Whereas from a court perspective, that's a more adversarial one. So that's one where you've got 2 people on opposing sides, and it's not the judge's job to really help either of them make their arguments. And it's interesting, particularly, I suppose, Chris, in the second decision we're talking about today, the adjudicator clearly sort of went back a few times asking for more information to enable him to be able to make a decision. So it's not necessarily probably a less combative process is what you would call it.
A couple of other quick points to make. Adjudicators aren't necessarily bound by precedent. They will obviously take into account what's been done before, but it's not necessarily a precedent-based approach. Adjudication is meant to be the last resort. So the last ride, your last ride in the saloon, if you like. Really, the way things are set up legislatively, your dispute should be resolved by that point. But I think it's fair to say, Frank, it's operating the other way around these days.
It is. And I mean, and that's part of the process. We actually really haven't done a webinar on conciliation. That might be another one. But ideally, the Commissioner's Office, before you can get to adjudication, I suppose to enliven the adjudicator's jurisdiction in a sense, you've got to attempt to resolve the dispute yourself. Usually then, the Commissioner's Office, to the extent that you try that and it doesn't get an outcome, they will try to push you into conciliation, where they sit down with trained conciliators to sort it out. And only if you've tried, the conciliators tried, other than, I suppose, some exceptions when it might be a pure legal point about an AGM motion or something like that, then it's off to adjudication. So it's really almost a third step in trying to resolve a problem before you can actually get there.
That's right. And probably the final point to make about adjudication before we actually get into the first order today, all adjudication orders are publicly available. They're published on a register. and they're also examined and searched as part of the conveyancing process. And what that means is that every order is available there for a prospective purchaser to see. And think of it this way: if you're thinking about buying an apartment in a building and you do searches and they come back with 10 orders, 10 disputes in the last 2 years, for argument's sake, are you going to still buy that lot? Chances are you probably won't at that point.
And Chris, I'm going to ask you a question that I don't actually know the answer to. So this is a question without notice. Is it possible to have an adjudication decision locked down from a privacy perspective if there's a particular... No, end of story. It's done. It's public, no matter what.
I can think of one in my time, Frank, where... No, two, where one of the parties put forward some really compelling reasons and the adjudicator did not refer to them by name, referred to them as owner of lot 1, owner of lot whatever.
So you can still find them though then via RP data?
Yes, you can.
Okay, right.
Yep. So there is no redaction. No. Let's rip into it then. Our first order for the day, which we're just about to pop up there on screen, it's a building in Townsville. And I should point out, we haven't necessarily targeted anybody or anything in particular here. We've just picked out 3 that we thought were worth discussing. This is a building in Townsville, and this is a dispute about a dog.
Really?
Yes. No, who would have thought?
Disputes in Strata.
Yeah, I know.
When did that happen?
Yeah, no. In this one, the applicant, the owner, wanted to have a dog brought in as some form of therapy animal for a family member who had a mental health condition. Interestingly, though, Frank, in this one, the adjudicator dismissed the application, and that's interesting because there is a conception out there that all pet applications get approved. Not so, isn't it?
Conception or perception?
Could be both, but probably perception.
Yes, and the interesting part of this is that the reason it was knocked back was because another lot owner in the scheme had a phobia about dogs. So what we had was someone needing a dog as a therapy animal, someone with a phobia about dogs, which seemed to be evidenced in there, and tossed up before the adjudicator. So, and I think I highlighted a phrase in the actual adjudication itself, which I will bring up. The comment was, the committee was faced with competing interests with perhaps equally strong claims. And I suppose where this one, so today's not so much about the legal principles behind these disputes, it's about what other people could have done. Or what are the ways people could have approached these things? And I suppose the answer for the people that want to read the last page of the book first is that the dog was refused, and effectively because there were equally strong claims, but it was first in best dress. There was already an owner there who had a phobia, so therefore, really sorry, you can't bring a dog in with that. So again, highlights, I suppose, the ability for adjudications and adjudicators to make decisions that are just and equitable in the circumstances, because in theory, you probably could have tossed a coin and gone the other way, and it might have been just and equitable to do so. But what we're talking about today is what else could have been done to avoid the need for this particular adjudication. And I suppose when I read this decision, and it's relatively short, there's not a whole lot of, yeah, compared to the next one, there's not a whole lot of history there about communications between the parties. So my immediate take was that it's probably all been done potentially in writing. Application made, application refused, probably nasty letters exchanged, no face-to-face communication, no discussions, and no discussions, I suppose, particularly between the owner who wants to bring the dog in and the owner of the owner with the phobia. As much as it's hard to tell that from the decision itself, but normally, I suppose, if there were extensive discussions, that might have even been referenced in the decision as a way that the parties attempted to resolve the dispute themselves. So number one for me is this is probably that typical, let's just get on email and fire things around, and it escalates before we've actually communicated. So, and Chris, I'll throw this to you then, I'll segue back. If there was communication, how do you reckon that should have been handled? Or how could that have been handled?
See, given the sensitivities involved here, Frank, because we're talking about two sets of medical conditions, and that's always a very, very sensitive topic for the parties involved. So given that, I actually think that's the first step is to not put it in writing, and you have the discussion in light of those sensitivities. And maybe it did happen, we don't know, but if it didn't happen, it's about the applicant going to the committee and saying, look, here's our situation and here's what we are hoping to achieve, and then having the discussion. And then in an ideal world, Frank, the committee would have come back and said, look, we've got a problem here. One of the owners has presented evidence, and that's the key bit about the phobia. They've presented evidence of their phobia of the animal. How do we get past that? A discussion could then ensue. Okay, what can we think about practically? And this is where knowing what your building is like and what it entails becomes really important. Multi-story, townhouses, whatever the case may be, what adjustments could we potentially make here to make this work for everyone? Maybe that happened, Frank. Maybe. I doubt it. Maybe it did happen.
What conditions could we? So I suppose, and you'd almost look at this, it's an all or nothing. I want to keep the dog.
Yep.
But I want to keep the dog with the condition that maybe it'll be on a ridiculously short leash if it's ever on common property. And I'll never, ever make sure that's not the case.
Or I'll it's muzzled on common property.
Yeah. I'll take it out the back door of the back gate. If it's townhouse estate, I'll put a gate in the back fence and I'll only ever walk him or her out that back fence, so it'll never come on common property and never come near that owner with the phobia. And I suppose that's where discussions, you know, short form mediation of some description or something like that might have led to an outcome where, well, actually, no, maybe that might work.
And the earlier the better, Frank. Yeah, you can't have that discussion with the dog moving in the next day. That doesn't work. And I suppose what I think out of all of this is that nobody's going to be happy here in this scenario, because you've got one family that doesn't have an animal that they've said is needed for a family member, and now they know that there's somebody else who's effectively prevented them from having that animal. I can't imagine life there being rosy or happy after that. And nobody wins. I think it's a really, really clear case of how be careful what you wish for, because if you wish for the umpire's decision, well, you've gotten it, and I dare say nobody's happy now. I'd be quite surprised if that.
And it's interesting too, isn't it? Because I suppose ladies and gentlemen, we haven't really prepared for this in the sense that we're just having a conversation like we would do normally over a coffee, talking about a decision. So I suppose the owner seeking the permission to keep the pet may have just written into the body corporate manager, like you normally would, say, "Hey, I'd like to keep a pet," and maybe there was just a refusal straight back.
Maybe, yep.
You know what I mean? It's sort of maybe a phone call to the body corporate manager to say, "Hey, I want to come keep it. I want to keep a pet." Oh well, mate, we've got a problem with the owner of lot 5. I don't know which lot it was. They've got a pet phobia, so we've got to probably do this one a little bit differently. So it's sort of that. I suppose, and that comes with day-to-day business, doesn't it?
It does.
We'll send emails and letters all day, every day for something that could be vanilla that turned into something quite different. And I suppose part of that then is when you realise it's gone off the rails, is trying to get it back on the rails by having that communication straight up.
Definitely, Frank, definitely. We've got a few comments there. Thanks, everyone. A few questions. We'll get to those towards the end today. If you've got any more, please put them up. We'll try our best to get to them all. Here's our next adjudication about to pop up on your screen. So our order number 2 today is about termites. Bit of an old favourite in a body corporate, and a difficult...
And waterproofing, I suppose.
Termites and waterproofing. Difficult issue, because this is money, it's work, it's the whole box and dice. And I think anybody who's ever been presented with either a water ingress issue and, you know, preview of coming attraction, Frank, we'll be doing a water ingress webinar in a couple of weeks.
H2O.
Yep. But anyone who's ever been involved with water ingress or termites, it's particularly stressful and emotional, those issues, because
122 paragraphs in this decision.
It's a huge order. So in a nutshell, what we have here is an owner who claimed damage from termites, said the body corporate should be responsible for that. A very, very long history of dispute about it. And essentially what it boiled down to is the body corporate said it's going to cost them too much money. I can't afford to do it. I mean, there's a lot more to it than that, obviously. But Frank, what happened?
Yeah, and I think this went on forever, and there's also some waterproofing issues. So there's really sort of the two whinges going on, and it was not over a whole lot of money. I think when you look at this decision, I think the order itself, and sorry, Chris, I'll bring it up and go back to the top. There I am. I think the orders were 2,800 for the waterproofing and 1,400 for the termite issues. You know, it's not sheep stations. Yet it was sort of 10 lot scheme, two owners supporting it, obviously one who was affected, 5 owners were against it. So you'd say a largely engaged community, but had gone on for a long time. And I know we had a leaking roof in our place for a while, in the joys of older houses. And every time it rained, it was just like we had to get the buckets out and make sure that everything out of the way. It just drove us both nuts. And it's almost leaving your house. You almost checked the weather forecast before you went to make sure you didn't have to put the stuff out.
Yep.
So how you live with that for that long, I think, is beyond me. But I suppose at the end of the day here, the other reasons that the body corporate seemingly refused the works was that the quote's 10 months old and it's out of date. So really technical, sort of spurious ground. And then that really isn't, as the adjudicator pointed out, a basis for a body corporate to refuse to comply with what its statutory obligations are. And one of the other ones was, well, the guy who gave that quote's actually not capable of doing the work anymore. He's crook. So, you know, they really descended down into that level of, you know what, we're going to find any reason we can to make sure this doesn't happen. And I think this decision, Chris, one of the other things, the owner was accused of acting in their own self-interest. It's like, but who doesn't? Yeah, I want my waterproofing done, and I want this termite issue fixed. They're entitled to do that. And in fact, it's sort of unrealistic to a degree to expect people to act in the common good as opposed to in their own self-interest. So when you go through this whole history, it's quite interesting. And I suppose at the end of the day, again, turning to the last page of the book, the adjudicator just logically worked through, yes, it's a piece of common property. Yes, the body corporate's got a statutory obligation to maintain it. Yes, the body corporate must do it, regardless of whether it wants to or not, and regardless of whether all of the owners tie in, and regardless of whether it's got the $4 and a bit grand set aside for that decision. If it doesn't have the money, it's got to go and raise it.
That's right.
But this dispute, I suppose, from start to finish, not so much the adjudication itself, seemed to have been dragging on for years. So again, what could have happened here to stop 4 years, I think, really, of pain?
The first thing, Frank, I think we've already highlighted that, is to put yourself in the shoes of the other party. And you spoke from personal experience about water leaks. If someone's living with that for 4 years, surely at one point you can put yourself in the shoes of that person, and you don't have to be sorry for them, you don't have to have pity for them, but you do need to understand where they are coming from. The idea that you would then put a series of hurdles in their way to getting it resolved, that doesn't speak well for anybody. And I think the adjudicator has highlighted that very much in there.
That would be relatively aggravating, wouldn't it?
Absolutely.
We run your contractor and he can't do it, mate, so no.
And the adjudicator absolutely takes that into account, how you've conducted yourself in the process. If you have gone out of your way to be difficult, the adjudicator will see that and will comment upon it, and it may contribute to the end result. The idea that we're not going to do something because we don't have the money, too bad. The adjudicator is very, very blunt in this order, that doesn't matter. If the body corporate has to do it, it has to do it, and it has to find the money. It's not a case of crying poor. Body corporate can't cry poor. Probably the other thing that leaps out at me, Frank, is just there are some governance issues here in this building. The committee doesn't seem to have a great grasp of governance, proper governance. That's not a surprise. Happens in a lot of buildings. So, mate, there's a free training that can be done for committee members out there. There are other places to get committee training. There are ways in which owners can exercise oversight as well.
And And I think, interestingly enough, with this one too, because all these decisions now are traversing the old regime and, well, really the old regime. Not many of them in the new regime. This owner put this motion to general meeting to have the body corporate vote to do these things. Now, this sort of work probably is within the spending limit of the committee. So now, with the ability to put an owner's motion to a committee, and there being a deemed refusal if the committee doesn't respond within that time frame. What have we got? 6 weeks and 6 weeks if they need to extend, isn't it?
Yep.
So 3 months later, you know exactly where you stand, but this wouldn't have been that hard. So, and I suppose this one to me highlighted to a degree what we're trying to do with these webinars. We've had a bit of feedback this week actually from a range of viewers who've been saying how much they've been enjoying it. Joan, that's you specifically if you're watching. But it's trying to help people understand what they should be doing to avoid this sort of stuff, because there was a bit of an educative process here, probably on both sides. And that's not trying to be facetious or arrogant or anything like that. Like, this stuff is complicated, but it's sort of, I don't think the committee actually knew what their obligations were, what their rights were, what common property was. And I don't think the owner knew either. So what we had was sort of the blind leading the blind in terms of requests going in and refusals coming back, and the owner not driving it the way they could be driving it. And, who knows, 3 years worth of grief that if there had been more education, more, I suppose, research on either sides, the body corporate committee saying, hang on a minute, is this the right thing for us to do? Don't know if they had a professional body corporate manager. Like, I still think, as much as, the Act in theory supports self-management, I think you've probably got rocks in your head to try to do that. A good body corporate manager is an essential part of running one of these complicated body corporate businesses. And even a 10-lot scheme, there's a lot of moving parts, even a building format plan. What's the difference between an owner's obligation and a body corporate obligation? And the owner doesn't know either. So what we had was a whole lot of to and fro where everyone's asking things, but no one stopped. Chris, I suppose, as we were doing last week, what is the problem?
Yep.
Let's identify the problem.
And here's the result. Here is the result. 120 paragraphs to sort it out. We've got one more to go. Frank, we're going to have to speak really quickly on the last one. I see there are a few questions there. We will get to those at the end. Here is Order 3 for a building up north. And this is about the thorny issue of nuisance. And so this was an application brought by the body corporate against an owner seeking an order that the owner be an order of nuisance against the owner. And this was based upon the idea that the volume and frequency and indeed tone of email communications from the owner was causing a nuisance. And in fact, this was one of two that the body corporate, the same body corporate, took out against two separate owners, more or less at the same time, it would appear, but we're just focusing on one of them today. So the adjudicator in this one, I've got to give full credit to the adjudicator on this one. They went into a lot of detail and tried very hard to explain, because I think the adjudicator was picking up that there was a real problem here at this building. And so the adjudicator tried to make really plain to everybody what the issue was. And the issue effectively was that even if the adjudicator found that this email communication was a nuisance, and the adjudicator was not convinced that it was. What's the classic line, Frank, from this order that you and I both picked up on?
Everyone is entitled to their opinion, even if it's wrong.
Interesting.
I love that line. I'm going to use that a lot. So, but yeah, and so it's sort of the body corporate. So this one to me is, and this scheme has a long history. So obviously there's some very entrenched personalities in there, which is what happens when we get into these fights. To me, this is the circuit breaker. This is really that the facilitation / challenging person process, leading to a straight plug for Hynes, is what Chris provides to help people deal with this. And I think even when you looked at the history of the correspondence, it was almost 10 emails a week for 2 years. And, repetitive, voluminous, not necessarily aggressive. And to a degree, I think the adjudicator at the end sort of said, in terms of the person sending the emails, perhaps you could do that a little bit more professionally. And to the committee, perhaps you might respond in a different way as well.
Yep.
So it's this, what is the circuit breaker to stop this going on? Because people are emotionally involved with what's going on. There's been a lot going on with this building. And again, we're back to that communication piece. We're sending stuff to people who you don't necessarily like and who don't necessarily like you is not going to get a different outcome. It is just going to continue.
And critically in this one, I think, in addition to all of that, Frank, critically in this one, the adjudicator made the point that, again, even if you agreed that the communication was a nuisance, legislation provides that it has to be in relation to the use of a lot or common property. And to be frank, there is no way, or very few ways, to prove that an email originates from a lot or common property. Yeah, no, who knows? And so with that in mind, the adjudicator had no option to find nuisance in that particular case. And so it failed. And again, as Frank said, it's a history, it's a scheme with a history, and that's just going now to continue because you had a formal action taken against someone and it failed. So things continue.
And that'll invigorate the person against who it failed.
It will. That's right.
You tried to shut me down. You tried to shut down free speech.
Absolutely.
I think one of these referred to something. This is not allowed in a democracy like Australia. That was another line I got from somewhere in there. Anyway, but yeah, that's that circuit breaker element for this one. Like it's just that typical deep into the morass of firing or throwing stones at each other for years.
Yeah.
How do you break out of it?
How do you break out of it, Frank? That's a really good question. And I think the point that we want to leave, and we will get to these questions in a second. Well, the point we want to leave out of today, we just picked these 3 applications out of there. We're not saying that there's always going to be another approach to adjudication. There are absolutely instances where that's the only choice. You have to get it resolved that way. That's the only option left. But we think there are plenty of disputes that could benefit from a different way of approaching them. Again, as Frank said before, shameless plug for the work that we're doing, but that's what we're doing. It will save a lot of time, 6 to 9 months for an adjudication.
Well, and all of these are taking, I think, every bit of that time plus a little bit longer.
A lot of angst and a lot of money. It's not just the cost of legal advice or being represented. It's got to remember, every time there's an adjudication, every single owner in the building will pay. And they pay because the application has to be distributed to all owners. Somebody has to do that. It's usually the body corporate manager. It's an additional fee for them to do that, and it is not cheap. And particularly if it's a big building with a couple of hundred owners, that's a whack of money. And if that happens several times each year, every owner is going to be paying for that eventually in the form of increased levies. Let's try some of these questions, Frank. From Keith, not really a question, but a comment. Thanks for tuning in, Keith. Interested in this topic because you're part of an adjudication at the moment. Hope this has provided a bit of insight. Drop us a line if it hasn't, and we'll see if we can assist further. Hatlow Heights, thank you for tuning in. Very specific question there about caretaking agreements, which is not really what we're covering today.
But I'll do that super quickly. The reality is you've got an agreement. It says what it says. There's no way to alter a caretaking agreement unless the agreement itself allows it, which is pretty unusual, or the parties agree to it. In terms of interpretation of the agreement, that's where the lawyers get involved, unfortunately. If a clause could be read 2 different ways, it's not up to anyone to dictate what that says. That's unfortunately what sometimes goes on in QCAT.
Drop us a line.
That's a more specific legal question.
Yep, drop us a line, please, Hatlow. Lucy, thanks for tuning in. Who pays for adjudication expenses? The person who puts in the application.
And there's usually no costs in these things.
Yep. Jojo, thanks for tuning in. If no mutual resolution obtained, is this then BC to decide to proceed under bylaw? So I'm assuming there that you mean that somebody says the bylaw is being breached, it's disagreed. The body corporate ultimately has to decide, are they going to enforce it or not? If they decide no, but you think that the situation is continuing, then you can opt to proceed further after that point. We're doing bylaw enforcement next week, so tune in next week, you'll get some more answers to that. And then Jojo, a very specific question about body corporate versus owner responsibility. Very difficult to give you a definitive answer on that one.
Depends what type of plan format you're in, but that still is right up there in the probably number 1 dispute, number 2 dispute in the Commissioner's office about maintenance responsibility. So that is really confusing. Does depend on a few things, but we can quote you on that if you need it.
Neil, thanks for tuning in. Any suggestions regarding visitor pets? We have a resident who insists on allowing 2 visitor dogs in addition to his own. Council has 1 dog limit. Depends what your bylaws say, Neil. So there's council and then there's bylaws, but if it's contravention of a council local law, then council should be notified about that. They're the ones who enforce that. Otherwise, it's about your bylaw. If you've got a query about your bylaws, drop us a line, Neil. That's something that we can have a look at. Bridget, thank you for tuning in. Group of investors who have the majority voting power refusing to increase the sinking fund, been going for 8 years. What are our options other than adjudication? Well, drop us a line on that one as well, because we can give you potentially those alternatives in that situation.
Yeah, it's really, sinking funds are really interesting in the context of, as much as you must have a sinking fund forecast, there's bugger all governance around what that forecast actually includes. Obviously, there's professional companies that do it, but if I felt like doing it on the back of a beer coaster with my treasurer, Chris, then we could do that. Absolutely. So, but it's still, yeah, okay, yeah. Again, that's not a deep and meaningful one, but there's probably a couple of ways to approach that.
Yeah, there's a bit involved in that one. Drop us a line on that, please, Bridget, and we'll see if we can assist. Goodness me, not only are we finished, we're well over time today. That was
Sorry.
That went really well, and a lot to say. I think what's pretty apparent out of that one, Frank, we'll be running a part 2 of this particular topic coming up. And
you might know some buildings that could be interesting to talk about decisions, wouldn't you, Chris?
Quite possibly, I do.
And yes. none of these we're acting for. So staying a mile away from things that we actually have the inside knowledge on.
Yeah, and lest anyone forget that we're talking about things that are privileged or private. Nope. All of these things are out there on the public record, so you can go and have a look at it yourself. Thank you all very much for tuning in. We're getting some really nice feedback from people, so I really appreciate that. Thank you. Next week, the thorny issue of bylaw enforcement, and if we can get our camera working properly, we might even be able to do a screen share with everyone.
Technology, look at us go.
Yeah, but yeah, bylaw enforcement, we're actually going to delve into the nitty-gritty of it next week, so essential viewing for everyone. Until then, as I say, don't forget to register to get a reminder of that. If you're thinking of any more topics that you want us to cover, we got one just before, shoot us an idea. We'll see if we can cover it off in the coming weeks and months. But for now, Frank, thank you as always.
See you, everyone.
See you, everyone. Thanks again for tuning in.